Do you qualify for an uncontested probate, also called an informal probate in Colorado? After the death of a loved one, when all the interested parties agree, that could be a way to use the court process of an uncontested probate. When there's agreement on whether or not there's a valid will, who the legal decision makers are, and how assets are ultimately going to be distributed. There are multiple benefits to an uncontested probate, which include less court involvement and less emotional and financial strain on loved ones. Now, if one interested party raises issues, it could move a case from being an uncontested probate to being a contested probate. So if any of the following things happen, that would disqualify you from pursuing an uncontested probate and force you to pursue a contested probate. If there's only a copy of a will, but not the original will, in Colorado, that triggers a formal probate requirement. If there is disagreement on whether or not a will is valid, and an interested party will challenge the will based on either lack of capacity, undue influence, that would be another reason. If there's disagreement on who the valid creditors are and how much they're owed, that would also be a disqualification. If there's not agreement on who the legal decision maker is, if there's disagreement on how assets are going to be distributed, both of those would also disqualify an uncontested probate. So if any one of those are true, we're moving from a world of uncontested probate to contested or formal probate. Now, even when you qualify for uncontested probate, it is still a good idea to hire a seasoned probate attorney to keep the process moving smoothly, to avoid confusion, and to avoid surprises.